Welcome to Pep Talks with Jeannie. I'm your host, Jeannie Pepper. I started doing Pep Talks as a way to inspire you to do intentional acts of kindness and to further the goals of #BlazeItForward. Since its inception, Pep Talks has evolved, and now I use it to interview people actively making a difference in this world through their volunteerism, community service, or careers. My guests are all here because they have dedicated their lives to making this world a better place. Join us as we delve into the hopes, dreams, and aspirations of these truly inspiring and hardworking people. This season, we will be using a panel format in some of our episodes to bring together synergistic guests to discuss topics that weave the social fabric of the world around us. Welcome to another episode of Pep Talks with Jeannie. We're in panel now with Gideon Bernstein and William Weinberg, my friend and our attorney who helped us through the People versus Woodward trial this summer. This is going to be just a debriefing. Let's talk. Let's talk about what happened this summer.
Sounds good.
Yeah. What was your takeaway?
Well, I think that it was the most litigated case that I can recall in my career. I feel like all the issues got put into the sunlight in this case. Maybe definitely not as quickly as anybody would have liked, but they were fully litigated. I was fortunate enough to be in chambers on a number of hearings where a Marsy's Law attorney would typically not be permitted. But the judge, I think, construed the Victims' Rights Bill a little bit more liberally, knowing that my relationship with you was very close, knowing me personally. She's also a neighbor. I've known her for many, many years. I've known everybody there for many, many years, so it afforded me a little bit more access. And I got to see that they litigated every conceivable issue in this case. And that was a good thing for appellate purposes.
Yeah.
At minimum.
Yeah. Will there be an appeal? Have you seen
100%
anything?
chance.
Yeah. Will there be a motion for a new trial?
I don't know at this point whether there will be. The attorney for the defendant made such a solid record of his objections that they're in the record that can go up on appeal. So the appellate attorney, whoever that is, can cite to those objections and use them for their purposes.
Yeah. I mean, who knows? The Menendez are getting another trial.
That's right.
And
that's right. They may, they
Yeah.
may just get resentenced.
Oh.
They may not even get a new trial. They might just get resentenced.
Wow.
Well, part of the reason is, not to digress from our fact pattern, but
no, this is important stuff.
they were young, and that trial was, 30 years ago?
Mm-hmm.
Something along those lines?
Around the time you started practicing law.
After I started practicing, I was already a veteran of
You could have represented them.
3 or 4 years. They were, I think, under 25, and the law has changed so that you would otherwise be eligible for parole on certain sentences. Now, I don't know exactly what their sentence was and whether or not the resentencing laws, the new sentencing laws would apply to them, but that may affect it, and it seems like the DA in Los Angeles is considering that, although there's a lot of opposition to it.
Yeah.
So,
what are your thoughts?
I haven't followed it as closely. They claim to have been victims of sexual abuse by their father. I don't know if any of those claims were substantiated or simply trotted out for defense purposes to create sympathy amongst the jury.
And chaos.
Well, sometimes that does actually work.
I found that to be a major part of the trial I sat through this summer was chaos and chaotic reasoning.
I think their attorneys will do whatever they can to bring any mitigating issue in front of the DA, and ultimately it would go to a hearing in front of a judge, and a judge would decide. The DA can't on their own motion do anything. They can make recommendations and they can make arguments. Mm-hmm. So we'll see. Sometimes they don't go anywhere. If you read any of these stories nationally, sometimes these DAs who come back with oh my gosh, I really regret how hard I pursued this case in 1942 or whatever, they come back and the judge goes, no, there was enough evidence. I'm not changing anything. So,
And
and the appellate courts say, yeah, we're not granting review. So anything could happen
Yeah.
as far as the Menendez brothers.
Yeah. And in this case, can anything happen?
I just, as much as you see it as chaotic, I didn't see it as chaotic. I saw it as, the defense looking for any vulnerability they could in the prosecution's case and trying to raise as many issues for appeal as possible. The way it was done in such a way that it made the trial take longer. There was it made it slower. There made it for a lot of sidebars, a lot of chambers conferences and things like that stop the flow of witness testimony, right?
Yeah,
and can run out the clock for the day so that then you have availability of witness problems down the line. So,
yeah.
I know as an example that the judge in Blaze's case does everything she can to get cases to move faster, including picking a jury on one trial and doing closing arguments on another trial on the same day. So she really tries to keep it going as much as she can all day long because of a backlog of cases.
Yeah.
In his case, the Woodward case was a long cause case, and there's only a few judges who do long cause matters. I'm telling you something for this podcast that you already know because we talked about this a number of times.
Yeah.
And a certain number of judges do those long cause cases with the eye towards moving them along and getting them done in as orderly a fashion as possible. But remember that Judge Menninger in our case knew who all the previous attorneys were, and so understood that the case had been around for a long time and wanted to get it done. She pushed along the case, I thought, as much as she could.
Yeah. I think for me, and I'll let Gideon talk about this, the fact that we had to listen to so many weeks of testimony on the victimhood of the defendant made it nearly intolerable for me. And I don't know how you felt about sitting there listening to our son being vilified.
Same.
I found that to be the most egregious, despicable thing that I have ever had to be a part of and could not leave and was forced basically to participate in order to preserve my son's rights.
I'll tell you that as a defense attorney, it is incredibly difficult to present testimony that sheds anything positive on your client's life when you have the victim's family present. It's unnerving to have to do it because you know that the family of the victim who's done nothing wrong is hearing this and that they want to leap through space and, knock you upside the head. It's just a very, very difficult process, but it has to be done. That's just part of the job, is to get as much mitigating evidence as you possibly can into the mix for the jury to consider. A lot of that stuff that you're referring to was done in limine motions too, right?
I have
no
idea.
Well, where the jury was not present,
right?
Yep.
Then there were all these motions and exasperation, counsel, you didn't give me any moving papers on that issue, and you're just bringing that up now. How can I rule on that if you didn't give me any moving papers?
Right.
And then the defense attorney would go through this very loop-de-loop argument about why he didn't or shouldn't or can't or would, to the point where you would have a hard time following the reasoning. And to you guys, it was just prolonging and exacerbating your pain.
Oh, it was excruciating.
Yeah.
I mean, I had to sit there and listen to lie after lie from this person about what happened the night he killed my son.
You're talking about his testimony.
Yeah, his testimony
Right.
was, it just was complete fantasy. In my mind, based on the evidence and what I know about my son, there was no truth to anything he said. But the evidence showed that. I mean, the jury was able to
The jury didn't
determination.
buy it for a second, and I was taking contemporaneous notes during that testimony and thinking to myself, if you were writing down what you needed somebody to say, this would be it.
Mm-hmm.
This is what you would want them to say. My mind went blank. I don't really remember,
No, we've never heard that before.
Well,
what was that, fatal vision?
It's the yada, yada, yada defense, which is I'm not going to get stuck having to answer questions about the specifics of a particular moment because I just don't remember.
Oh, yeah. And then when I could remember, I was so enraged. And that's not even a defense anymore. You're not supposed to
Right.
use that as a defense. So that was improper, but it was allowed.
Well, if he was seeking voluntary manslaughter verdict, then you would want to talk about being enraged. You would need to. That's why his testimony was absolutely necessary. There was no way that the defendant had a chance at all unless he got up and told a story.
But how do you balance that with the gay panic defense not being a defense that you're allowed to use? How do you balance that with being able to show that passion, that rage?
Well, this is where it gets kind of sophisticated if you think about it, because gay panic deals with reacting to somebody making a pass at you. I'm not quoting the law here, but
Right.
I'm paraphrasing. It deals with panicking when somebody makes a pass at you who's gay, and thus you flip out and you attack the person, right? And we know that that's not a legal defense. But what I think the defense did was invert it and say, I didn't want to be outed, and I thought that photographs or recordings were being made of me at the time, and so I flipped out. Right?
Yeah, I mean, it made absolutely no sense. But
that is internally logical, if completely unbelievable. It was unbelievable to the jury.
It's not logical when you have your face on dating apps trying to lure men with your face and pictures of you holding guns and knives and all this other stuff and claiming that you don't want anybody to know.
Well, the jury obviously didn't accept it, but just from a tactical standpoint, the defense had to run with this. They really didn't have any other choice. They had to run with the idea that he was struggling with his own identity.
Yeah, I felt like it was like a snail's pace, not a run. There was no sprinting of that defense.
Well, that might be the stylistic, your observation of his style and his tempo, which I understand because it was at times extremely protracted. But I think that he did what he needed to do in order to have a colorable defense. The old Secretary of Defense during the George W. Bush administration, I'm forgetting his name now because of the bright lights of your studio.
Oh, yeah, I know. It has that effect on people.
He said, when asked about some of the supplies that the military was dealing with in Iraq in the early 2000s, you go to war with the army you have, right? And that's what the public defender did. He said, this is what's available to me as a potential defense. I can't make up stuff out of whole cloth like an asteroid flew down and blinded me and I attacked somebody. You have to take the fact set and do something with the fact set. And that's what he did. It might have been not very good, not very helpful, but he did what he did with what he had.
Yeah, I really liked the way, and I'm being facetious, that
I got that.
The story changed so many times over the years about what happened.
Right.
I mean, but that never really seemed to come up.
From your perspectives, the two of you, and dealing with this, even with your legal training, it was just excruciating, to see, not to mention which the family hired a private attorney who did the preliminary hearing. I still have my notes on my phone from the prelim. And I knew that lawyer was not going to be retained post-preliminary hearing. It just I didn't think the family could support economically that decision. Plus, you need all this investigation. This is the hardest part in my profession, is getting families to pay for investigation to flesh out all the facts, right? When you have a public defender, you don't pay for anything. They do everything. They have basically almost unlimited budget. But you guys caught the first public defender getting appointed to become a commissioner. And he had the case for what, a year? And then another, I think it was Allison, blanking on her last name.
Do Nothing? I think that was it.
What's that?
Allison Do Nothing?
Allison Do Nothing?
Yeah.
Well, Allison...
Allison Stonewall.
Oh,
that
that's
one.
right. That one.
I'm mindful of the fact that I'm still swimming in the same pond every day, and you two fish climbed out and you're now land walkers.
Yes.
But Allison, and I'm blanking on her last name, she had the case for a long time and never got the case off the ground. And then she got a job as a magistrate, I think.
Oh, because let's take the people that do the least amount of work at their real job and give them a higher
This
paid,
is the
easier position.
sarcasm again, right?
Oh yeah,
Okay.
no, I'm all about that.
Right.
I could be a magistrate because I haven't practiced law in 31 years.
You should.
So
You should do it. You should become a magistrate.
I should be I should
Yeah.
be. Yeah. Is that an appointment? How do I get that?
Yes, it is.
Oh, I need to be appointed.
I think so.
Oh, so whose car did she have to wash to get that job?
There's more than one car.
Oh, okay.
Yeah.
Should a
was
number
more
of
than
cars,
one car.
a jail bus?
Right.
Okay. Well, that's good. I'm good.
Besides the delay, what was the hardest part for you?
Besides the delay was having to listen to my son being vilified, and that was the hardest thing for me. And the second hardest thing was having to leave the courtroom because there were pictures of my son's body, post-mortem, being shown to the jurors, and I couldn't even be in the room if they were looking at it and I wasn't seeing it. It was so horrifying to me. I still have trouble with that. I lose sleep over that, just thinking about what happened to my son that night.
Of course.
And I probably always will. It's just a trauma that I'll never get over that. So yeah, that to me, I'm just grateful that I was able to respectfully leave the room and not cause a bigger scene than I probably did.
I've been around this for a long time, as you know, 31 years practicing in Orange County, and I've never seen a family do more with tragedy to make the world a better place than the two of you. Never, not even, it's an order of magnitude more than I've ever seen. To start a foundation, to publish, to broadcast, to convey everything that's positive, not only about him, but his influence on the world and his influence on you and the way you have taken that and advanced positive thinking and the generosity of spirit is just very, very unusual. I'm not saying this because we're doing this on microphones. I'm saying this genuinely. It's phenomenal. It's not something I've ever seen before. And it's an incredible legacy for him. You know, it really, really is. And it's an inspiration for a lot of people. And then you see that document that we were talking about earlier.
Yes.
It was inspired by the two of you
Yes.
as much as it was about Blaze.
No, we haven't talked about that, but
Right.
I have in my possession a note that was written to Blaze by one of the jurors, and it was found very close to where his body was found. So this juror went out of their way to go to the park and leave it there for it to be discovered by whoever. And it happened to be discovered by someone I know, and they mailed it to me, and it was still in good enough condition to read, even though it had been water damaged. But the gist of it is that that this person who did not even really want to be on this jury, they decided that they were going to do it because they wanted to do a public service, and they came out of it feeling very sorry for Blaze and for our family, and being very grateful that we have this legacy for him.
The two of you changed her life. Blaze changed her life. She's not going to be the same because of that. And her sense of her civic duty and her role in society is forever changed. I can just tell you, the worst part of doing trial work is jury selection, by far. I'm not a naturally outgoing person. You probably know that about me.
Well, sometimes you like to,
I like to
freak out.
I like to tell a story now and again. not a Sean Combs.
Yeah, not a freak off, a freak
not
out.
A freak out. But you meet the jury and you look at them and you see resentment and irritation because they're there. And I see, like, I love civics. I love civics. I mean, I guess that's kind of obvious being an attorney, but I think it's such an incredible opportunity and honor to be on a jury. I do, and I'm never going to get picked.
I know, me neither.
I'm never going to get picked.
I feel like that was the closest I'm ever going to be.
Right. But it's so dispiriting when people get up and they say, I can't serve because, I work, or I have a job, or my boss will be upset. It's like...
They need to be a magistrate.
Or I can't be fair, and know that they've been on the internet trying to figure out what it means to not be fair so that they'll get kicked off a jury.
Yeah, but this one was a tough one just because, it was hard enough to sit and have an option of walking out of the courtroom, but to actually have to sit in the juror box and endure 3 months. More with jury selection. 3 months of much of which they probably just didn't even understand what was going on because it was there's so much stuff going behind closed doors that they weren't allowed to know about.
Yeah. What was the hardest part for you in this trial?
I think the hardest part was just basically listening to the narrative of the public defender. That was the hardest part because I know that he knew what the truth was. And when he stepped in front of the jury and mocked a neo-Nazi group, knowing very well that the organization that he was mocking had criminals who were convicted federally of crimes, of preparing to plant bombs, and trying to make the jury think that it was just a whimsical organization, whimsical social organization.
Right.
That made me lose a lot of faith in the way that our system works when I know that somebody's lying in front of the jury like that. Not that it doesn't happen all the time, I'm sure, but that was the hardest part for me.
Yeah. Yeah. I mean, I was very upset by the things that I heard. Listening to the parents talk about the way lying, contradicting each other, contradicting their son, and then being asked by the district attorney if they lie and admitting that they do. I don't know what to make of it. It's like, are they telling the truth or are they lying?
You wonder after the passage of time if they can even separate the lies from reality.
You have to
and
wonder.
You imagine they didn't kill Blaze. They're not responsible for his death. But I know they felt somehow, on some level, they felt responsible. And they must have turned over in their minds 1,000,000 times the choices they made and didn't make
and
as
the evidence
parents.
they turned over that they were sorry they turned over.
Right.
Yeah, how much of that evidence did they not turn over that really would have made them look bad? They turned over a birthday card that their son made for the father with pictures which I was not allowed to see, which I think I should have been allowed to see it, but there were pictures there of supposedly with Nazi numerals on the emblems of the character who was a Nazi,
Right.
And other things, and they thought it was just lovely. They thought it was a lovely card, the parents. But she was upset that she had included it. It wasn't supposed to be included in the evidence. But I didn't understand why it's her determination, what's relevant or not. I don't know.
I don't know.
Yeah.
There's probably some pretty disorganized thinking going on. It sounded like the house was filled with chaos for many years with him. He was never a stable person, never successfully integrated into society. It seemed like it was almost from birth.
Yeah.
But I can't even imagine having to hear any of this from your perspective.
And I loved hearing that she gave her son testosterone for many years, even up until the time when he killed Blaze. They were giving him testosterone, which is something why? I mean, were they afraid he was going to be a sissy? Is that what that was all about? I mean, he was like 6'4". He was a huge man with anger issues, and they're giving him testosterone. I mean, they knew that. They had fist fights in that house that they admitted to, and calling each other gay and faggot and terrible things. And yet that really disturbed me when I heard that.
Very disturbing.
Very. And I have to wonder, what kind of a person would do that? Would think that a birthday card with, all these anti-Semitic tropes in it is good, gives a kid testosterone who has anger management issues for years. I just don't understand it. Not to mention the fact that a lot of really strange people showed up at the courtroom one day for closing arguments. I don't know why, but it might have been, they were from, I think, from the church that they went to.
Right.
And that was disheartening too, to see a Catholic church supporting this. Like the people that belong to a Catholic church, a holy place, a place where people worship, and they want to be part of this. They want to support someone that killed my son. I don't understand that. That was very disturbing to me.
I can only speculate on that. I just don't understand it, but I don't know why they were there. I don't know if it was, everybody is equal in the eyes of God, this kind of thinking that, he is,
except
all
my
of
son.
us.
Yeah.
Yes. So, listen, from the beginning of this case, when they dropped that letter in your door, that these were not normal people. These were people who did not understand boundaries at all.
Yeah, and what Bill is referencing is a letter that we found on our doorstep that was very inappropriate. Soon after we discovered that their son had been involved in Blaze's disappearance.
Right. It never should have been dropped off. I don't care what it said. If they wanted to communicate, they should have just given it to the police. If they couldn't have already figured out emotionally that they shouldn't try to communicate.
Yeah. But, very, very strange.
And then again, during the trial process.
Yeah. But, I will say that that receiving this message from this juror it's almost inspired me. It is a takeaway. It's something so rare that this person did, that they were willing to do, that they put themselves out there to write this letter to Blaze, to leave it there in the park for to be discovered. It kind of gives me faith in mankind that, there were a few people in that courtroom that are despicable.
Right.
But the vast majority of people in that room were there for us, for Blaze, or they were there to serve a civic duty because they opted to be jurors on this case and to do a very kind act, because even though we're required to do it, like you said,
right,
many people find ways not to, and these people were willing to sit through a 3+ month trial.
To Gideon's point, I mean, an extraordinary demand put on the members of the public to sacrifice their lives to hear the facts of this case, which they knew was going to be terrible.
Yeah.
There aren't non-terrible 3-month trials,
Yeah.
unless it's a financial crime. But even those don't take that long.
And this, they obviously didn't know anything about this. They had whatever circles they run in, Blaze never crossed their path.
Maybe some story on the internet, or
they didn't remember
the
anything
register,
about it.
right?
It happens. There are probably plenty of things that I miss, even, and then...
Or you turn away from because it's just too awful.
Right.
Yeah.
And these people seem to me to be the kind of people that would turn away from terrible things,
right,
because they're not terrible people. They want to live good lives. And they are. I was very concerned that there could just be one person on that jury that was not there for the right reasons and could cause a mistrial.
I've had them on my juries.
Yeah.
Where they're just disruptors. They want to create a mess. Mm-hmm. They just take up an opposite position because it's the opposite position.
And you don't know.
Yeah, what's amazing about the system, though, is that even though we sat there knowing in our heart of hearts what the outcome should be, that we still had to have a question in our mind all the way till the end that, how is this really going to turn out? What really is the outcome going to be? Because there could be, we had no communication with the jury whatsoever throughout the whole trial. Hard to read what they're thinking, saying, or doing the whole time.
I never made eye contact
So,
with any of them.
the system worked from that perspective. As broken as I've told you, I feel like our system is. Basically, and, basically sitting through, I think I sat through about 90% of the trial, still just didn't know what the outcome really was going to be at the end of the day.
Did you, Bill? Were you fairly certain it would be a conviction?
I was concerned that he would try for voluntary manslaughter and would end up as murder too.
Mm-hmm. I was concerned about that as well.
And I just didn't, even like Gideon said, all the way down to the wire, your mind plays tricks on you and you don't have communication with the jury and you don't know why that's the case. But then I've had jurors say to me, I didn't want to make I was really trying to avoid making eye contact with you. Jennifer wins a lot of her cases. I'm sure, I don't know what her win rate is. I'm sure it's very, very high. She's a DA with, in the Orange County DA's office. They win a lot of cases, and I've nothing but respect for her. But it's, when you're a defense attorney, you're really trying to read the tea leaves. You're really trying to figure out whether the jury is responding to what you're saying. Part of the problem in our case that we're talking about here today was that the public defender was slow and halting and inconsistent and distracted. I mean, there was every sort of kind of behavioral characteristic that was coming out, and you're thinking to yourself, this is either not endearing him, but engendering sympathy on the part of the jury, or is this just infuriating the jury? I don't think neither of you talked to the jurors afterwards, did you? Wait, you did a little bit downstairs.
Yeah, I did after the verdict and
downstairs?
Going downstairs when they were walking out.
Yeah.
Okay. Did they comment anything about the process itself? I tried to stay back and just let you talk to them.
Yeah, that was just a very, I think, important part of the conclusion of the trial for me, because it's just, you have this such strong desire to want to just scream in the middle of the trial and yell at people and communicate with the jury like everything is in there, that you have to contain yourself the whole time. And the trial ends with a verdict, and then all of a sudden everybody is escorted out and it's over, and you more than likely are never going to have any communication with anybody who you just spent 3 months of your time on, and in aggregate 7 years of time of everybody that was in that trial room that was responsible for being in there. I mean, that's a big part of everybody's life if you really think about it. And I saw the jury walking out after the press conference from the second level of the courtroom, looking all the way down outside with the bailiff escorting them out. And so I just bolted and ran down there.
I remember I was with you.
Yeah.
Yeah.
And I don't remember who was around, but you came downstairs outside with me, right?
Yes.
And then I think Susanna, one of our friends, Susanna, came outside also, and then I was trying to get a hold of her.
I came down.
And I just asked the bailiff, I'm like, is it okay if I talk to them? And he said, if they want to be talked to, sure. So I yelled at them as, saying, excuse me. And then they turned around right outside on the, footsteps of the courthouse. And I just did a speech to them for 5 or 10 minutes.
Right.
So I really didn't get a lot of feedback from them on any of the details, but of the trial. But I told them how appreciative we were of the sacrifice that they made to sit through something that was that difficult and so time consuming. And gave them all big hugs and cries and thank yous, and some of them just said, we really were with you, and sorry that you had to go through all this. And I just told them, I said, you need to know more about who our son was, and
right.
I encourage you to learn about Blaze and Blaze It Forward and what we've been doing to try to help to carry his name along and do more positive things from the outcome of this, and that your time was not wasted. Right. At the same time, I told them that their time was spent and they have a lot of work to do to try to make up for that time that they had to be in the courtroom. And this didn't just start with what we see as the trial. It didn't start in early April. The trial started in January with all of the pretrial hearings that were going on,
right,
with the witnesses and all the different pleadings that were needing to get approved by the judge before they even went to jury selection. And that was stuff that we weren't allowed to be involved in. So just think about that just incredible amount of time that our system had to process in order to make a decision, not on whether or not this person was guilty of murdering our son. It was a question of whether or not he would get 15 years to life without parole. We spent 3 months sitting in the courtroom with a lot of nonsense just because our system allows that.
If I can weigh in briefly, just a couple of points. One of the things that I love about the law and being an American, and I think you'll echo this as an attorney, the system, the law, the rules of evidence, when we studied evidence in law school, so many things became clear. This is the operating manual for the system. Mm-hmm. This is the spine of the system. How do you make this process fair to both sides? Through all of the rules of evidence, through all of the motions that occur to finally get a fact set that both parties have to operate on and not throw the whole thing up in the air every single time there's a new hearing. And it's very, very complex, and it was very protracted in this particular case. The other thing I want to mention is the closing scene of one of my favorite movies of all time, 12 Angry Men.
Oh, I knew
you
it.
both know it. We skip over the set of the facts of the case, but the jury comes to a verdict and they're leaving, and it had been raining and it had been very humid, and they walk out, and Henry Fonda and one other juror are standing on the steps, and they wish each other well, and the other juror walks over to Henry Fonda and says, "My name is Wilson," and he says, "I'm Johnson," and he says, "Nice to meet you." And then they walk away forever. They don't know anything about each other. They don't know anything about anything. And that anonymity is at the heart of the system in a way. It just says you're a citizen, and this is your implied agreement that if you're called to serve in this little 12-person army, you'll show up and do your job. You don't have to know it. You don't have to like it. You just have to follow the rules we give you. It's a thing of beauty. It's not always delivered in a beautiful way, but it's a thing of beauty to me. Anyway, that's my little civics plug.
You can take people that are very different, a diverse group of people,
sure,
and give them a problem to solve.
That's right.
And see what happens.
That's exactly right.
That's what we had a problem solved.
Right.
And that problem's going to go away for a long time, thankfully.
Wow.
Anything else that you'd like to add?
We could talk about this for
we could talk about it forever, but it's it was a very difficult process to sit through, and a lot of our friends showed up day in and day out.
It's beautiful to see.
People would come in, and it was always a different group, and it made me so happy to see different faces every day. It would it would make it palatable. I could actually go there and feel the love in that room.
It was wonderful to talk to people about it and say, this is what it's like for a community to come together. Yeah. This is why I felt like my participation in this tiny part of it was so worthwhile, to be part of this community. That's a big part from what we were talking about earlier about being Jewish. It's a huge thing. I don't go to services. I'm not a religious person, but I really felt and still feel this tremendous connection that just never dims. I
love that.
Yeah.
It's we have a really fantastic community here in Orange County, and I'm sure in other cities there are communities like this as well. But
Absolutely.
we support each other, we care about each other,
and we, I don't think that we could have gotten through this without you as part of our community and really helping us out. And we're really thankful for that.
It was my privilege.
William Weinberg, the youngest of 5.
And which brings me to a question for you, Bill. So there was one point in the trial, I think it was around the time that all that nonsense was coming up about being victimized in the county jail, and the public defender turned around and thought that he saw Jeanne smirking at him or something of that nature, and then you went into chambers and then came back out and was trying to explain to Jeanne stuff, and I mean you were whispering while the jury was in there, like relatively loudly, into like a whisper yell match with Jeanne right behind me. How did you feel at that moment?
Really relaxed.
Okay.
Really relaxed. Yeah.
Were you ready to just pull the ripcord at that point, or?
No, I wasn't. I felt that I needed to match. I needed to level up to make everybody understand how serious this situation was. I didn't want anything to infect the jury process.
Yeah.
And I'm a generally very low-key person. I think I am. I may be delusional in that regard, but I think I'm pretty low-key.
Oh, yeah.
But I needed to come up to make sure that if I came up from my low-key level, you would know that it was significant.
Yeah, it's kind of like when Dad takes the paddle out. He doesn't have to say a word. You're like, I'm in trouble.
I understand. This is serious.
This is serious now.
Right.
Yeah, I mean, it was serious. But for me, I felt that my freedom, my First Amendment rights were being violated by that courtroom. And I do not appreciate the way that a victim's parents are treated in a courtroom. We should be allowed to express ourselves. We shouldn't be allowed to contaminate a jury. But if we cry or if we have a small outburst, that shouldn't be the end of the world.
Right.
And because that's normal. That's a normal human reaction. And they were asking us to be less than human in that courtroom.
I think the defense was trying to do whatever they could to suppress that.
Yes.
I don't think ultimately the court was going to do anything. I don't think she was going to do anything to suppress a genuine expression of emotion. It would only come down to whether or not there was a disruption of the court process by shouting and screaming and coming forward and making a scene.
And nobody was doing that.
No, of course not.
But it was exasperating to have to go through and listen and watch the videos of this guy, like, just completely sidetracking the jury on things that happened after our son was murdered by him, and using victimhood as a reason why he was decompensated with regards to his testimony. It's just that was really hard considering the amount of time that was spent on that during the trial.
Absolutely.
Yeah.
I will share one more thought with you, which was, I think, probably the point that was the ace card that was finally pulled out towards the end of the trial when the district attorney Jennifer Walker played a 2-hour interview from beginning to end of Woodward about 3 days after he killed Blaze, and the whole interview with the police that were just asking him questions before he was, quote, a suspect. And just listening to that narrative of all the lies that he told in that, and quoting, of course, the mastermind of Adam Waffen and his book, to me was probably the apex of illumination for the jury.
Right.
Mm-hmm.
So.
But hey, at the end of the day, we won. Everything that we went through, it came to pass that it was not for nothing. It was for something.
Look, I think it's an empty victory at the end of the day, and
We
you
would
do
have
too.
we would have had no victory if you hadn't been able to figure out who did this as quickly as you did. We did, but I couldn't have done it without you, and I didn't know how to use the computers as well as you did to be able to, and that's how we figured it all out.
Right.
Really, and it was our discoveries that got the law enforcement activated.
Well, you both worked together all the way through this process and presented a united front to the DA's office all the way through the process. Obviously, me running around saying they a lot helped, but it was you who presented that united front and let them know the durability of your desire to see this guy put away. They knew you weren't going away and that you were going to be a force in the process. And I told them at every turn, and I know Jennifer very well. She knew, she understood instantly who you were as parents to him. So,
and she's that parent to her kids.
Mm-hmm.
She would do the same for her children.
Oh, no question.
There's so much more to talk about. We are at this point. This episode is not going to be seen by the public until after sentencing, which could very well happen next year at the rate we're going.
In 2025.
Here he was. The verdict came in on July 3rd. And we may not have him sentenced until 2025. Kind of amazing, but
not going to change the outcome.
It won't change anything.
He's serving a sentence.
It won't change a thing. But that being said, a lot can happen between then and now. So I reserve the right to bring you both back for another debriefing after sentencing,
all right,
which will be shown after this episode, of course.
All right.
I want to thank you both for joining me today on Pep Talks. You are two of the most important men in my life this year. Gideon, of course, the father of my son and my cohort in the courtroom. Bill, my best friend. And for today anyway. For today.
You're
and
fickle.
We'll
You're
see.
mercurial.
It
could change on a dime.
We'll see what happens going forward. But yeah.
All right. I'll do my best.
Yeah, I love you both, and I'm looking forward to reading that victim impact statement.
Yeah, I was going to ask you about that.
And letting it fly, letting it go. So, all right.
Good.
Thank you, everybody, for joining us today on Pep Talks. Hashtag Blaze It Forward is a campaign my family started in 2018 after our son Blaze was murdered. Hashtag Blaze It Forward provides the inspiration to thousands of people to repair the world with intentional acts of kindness. If you would like to learn more about Blaze and how you can make a difference, check out www.blazebernstein.org or join our Facebook group at hashtag Blaze It Forward. You can also check out my website for this podcast at www.PeppTalksWithJeannie.com. There you can follow along with my podcasting adventures and learn more about my fascinating guests and their passion projects. I would like to thank all of the volunteers who help make my philanthropic endeavors a reality. Today, that includes my producer, Eli Moskowitz, all of the volunteer crew members who join us, and a special thank you to my son, Jay Bernstein, for the original theme song you hear at the beginning and ending of each show. This has been another episode of Pep Talks with Jeannie. Until next time, keep on making this world a better place.